So he's saying that this is an environment where they're trying to create a trial in public filings on the court docket, but everything in our system is designed to prevent that from happening. You said earlier when you gagged Trump that if we talked about this, it was going to wreck everything. Now you're reversing that? No, sorry, Judge. He already said that there were a bunch of sensitive materials. This court issued a protective order gagging Trump and gagging you and me from hearing from Trump. Donald Trump is rubbing Jack Smith's nose in his own words. Remember that in the January 6th case, Jack Smith wanted Trump gagged, did not want him to talk about witnesses and evidence. None of this could come out on the public record, or otherwise witnesses will die and America will be over because of Trump's big mouth, was Jack Smith's argument. And it's really what Judge Chutkan bought when she gagged him. But now, for some interesting reason, Jack Smith's entire strategy has changed. And now he wants all of that evidence put on the public docket. He wants to write it in a big, disgusting dossier. And he wants to make that public so that they can smear Trump because they're not going to have a trial before the election because they goofed their case. Forgot about that little concept called immunity that has functionally existed for 234 years until Jack Smith came into town. So now Jack has filed under seal a bunch of stuff, and he's telling Judge Chutkan that she should publish a huge swath of it, and it's up to her to make a decision on how to do that. And so Jack submitted this into the DC court, and he was saying, okay, guess what, Your Honor? I, as the prosecutor, the special counsel, will be filing all of this stuff, and it's going to include a bunch of stuff. Grand jury testimony, materials obtained through sealed search warrants, transcripts, reports of witness interviews, materials obtained from other government entities, and so on. And so we want to file this under seal, and so that you can take a look at what's in here, Judge, and then we'll publish a redacted copy of the motion on the public docket once we decide what can be published and not published. And then he goes through and he says, there's going to be a bunch, okay? The filing is going to be huge. It's like 180 pages. And he explained that he's got the right to do this, and the court can go through these various factors and make a decision on what's appropriate to unseal and not unseal. Now, Trump's people are saying, hold on, okay, not so fast. They've responded in an objection to Jack Smith's sealing motion. They're saying, you can't do this, Jack. There's a whole slew of logical inconsistencies here, buddy boy. Here's what Trump's defense wrote. President Trump, Your Honor, Judge Chutkan, January 6th case, respectfully submits this opposition to Jack's proposed redactions and all of this whole process in their motion for so-called motion for immunity determinations, which they have restyled in an unsuccessful effort to mask the fact that there is no basis in federal criminal procedure or in the Constitution for filing something that attempts to usurp control and presentation of a defendant's defense in a criminal case. So he's saying that this is an environment where they're trying to create a trial in public filings on the court docket, but everything in our system is designed to prevent that from happening. We're going to call it an opening brief, and we're going to call it a motion for immunity determinations, okay, which doesn't exist, is what they're saying. And in this new label, you know how much they like to invent labels. What do you want to identify this motion as? I don't know. Well, it's clearly an illegal motion, but I want to identify it as a legal thing to do. Well, you're Jack Smith. You can identify however you want. Identify the motion however. He says, I know. I'll identify it as an MID. Oh, an MID. Oh, good. He's probably going to put that in his email signature. But it's identified as a motion for immunity determinations. They say, what the hell is that? Never even heard of that. They say, look, here, this is exactly what he's doing. Jack's office referred to, for example, in September, earlier this year, last month, referred to presidential immunity filing more aptly. They called it a opening immunity brief, a superfluous, which is not responsive to any defense motion, right? In other words, Trump is not filing anything that would give them a cause to brief, and it's unnecessary. So he just kind of is making stuff up because the Supreme Court said, well, you have to do something about this. And he says, well, great. So I'll just do it. I guess the Supreme Court gave them license then to file whatever they want on the public docket. It's not exactly how the opinion read. So they continue. Trump's defense says the special counsel's office recently told the court, Chutkan, Jack's team writes, we spent, Your Honor, a considerable amount of time going through a protective order and making sure it could stand time. That was back in September 2024. Now, however, the motion reflects a largely unexplained about face on materials that Jack Smith already designated as sensitive. He said, we can't talk about these things. Now he wants to talk about them. And it also does not adequately address any of the implications for witnesses, jurors, or the integrity of these proceedings. You said earlier when you gagged Trump that if we talked about this, it was going to wreck everything. Now you're reversing that? No, sorry, Judge. The true motivation driving the efforts by Jack Smith, who's illegitimate, by the way, according to Judge Eileen Cannon, to disseminate witness statements that he previously previously sought to lock down, right? Why does he want to publish all this stuff? He said Trump can't talk about it like a couple months ago. Is inappropriate. The office wants their politically motivated manifesto to be public. Jack's manifesto. I am Jack's TDS. Contrary to Justice Manual and longstanding DOJ norms in cases not involving Trump. In the final weeks of the presidential election, while early voting has already begun. I am Jack's burning rage. Having criticized President Trump for, according to the office, trying to litigate this case in the media, remember that? Trump can't talk about this and improperly press his case in the court of public opinion. Their words, they don't want Trump talking about this. You have to be gagged. The office is now seeking to do exactly that in violation of the very restrictions they previously claimed were essential to, quote, the fair administration of justice. And do you remember, if you were here, we mocked that phrase into oblivion. They could do whatever they want. This was like Kamala's "I was born in a middle class" statement. Whatever happens. Why were you texting that woman? I mean, I was born in a middle class. Oh, okay, that's fine. Why don't you go over to her apartment then later? Now, while the presidential immunity filing contains few, if any, new allegations not already covered in other politically motivated and inaccurate lawfare efforts that Trump opponents have improperly funded and disseminated, right? It's all the same smears in there. It is irresponsible for the prosecutors to so quickly abandon the safety and the privacy interests that they already assigned great weight to in this case and in Florida when they were crying about this. Accordingly, the court should require Jack, illegal, to make consistent redactions regarding identity-related information and show cause why their proposed public disclosure of voluminous, purportedly sensitive materials will not pose risk to potential witnesses and unfairly prejudice the adjudication of this case. Yeah, what changed? Oh, we know what changed. Your trial's not going to happen before the election. You don't care about gagging or the sanctity, the fair administration of justice. You just care about winning and shutting Trump up. So here's the discussion. They say, look, President Trump has no objection to redacting the names of individuals who are already not specifically identified in this new second draft indictment. However, in numerous instances, the redactions and the pseudonyms proposed by Jack's office fail to meaningfully mitigate the privacy and the safety issues that they've already complained about. This use of functionally impotent redactions, which Jack Smith is familiar with, is flatly inconsistent with the office's approach to other filings here, where they would anonymize ancillary names, right? Elsewhere, they've been anonymizing everything. Now, all of a sudden, they want to reverse course and publicize everything. Therefore, to the extent the court is inclined to grant the identity-related portion of the motion, the office should be required to redact all references to titles and all witnesses and not name them. As this issue repeats itself numerous times in Jack's sprawling manifesto, the burden of applying these redactions should revert to Jack's office, not us. Now, Jack also takes an inconsistent position here. He already said that there were a bunch of sensitive materials. This court issued a protective order gagging Trump and gagging you and me from hearing from Trump, which are summarized and quoted at length in the filing. These materials include grand jury testimony, materials obtained through search warrants, transcripts, witness interviews, materials from government entities. Now, last August, Jack Smith, illegal, came into this court and demanded a protective order that they said was designed to, quote, prevent the improper dissemination or use of discovery materials, including to the public. Jack said, we can't see any of this because we'll all die. Part of the basis for that was harmful chilling effect on witnesses that would wreck the process. And dissemination of that information could adversely affect the fair administration of justice in this case. So Trump can't talk about it. Now, at the hearing related to the protective order, the court acknowledged it wasn't about this at all, okay? They just didn't want Trump to talk about the case, which is his right. And he's a defendant in this case. His free speech is his weapon against government corruption. I get so tired of hearing about the prosecutor. Oh, we're going to be improperly impugned. So that's the point, is to improperly or to impugn you. That is the point. Properly or improperly, that's up for the jury and the public to decide. But that's our right, is free speech. You don't get to suddenly complain about it. Now, this fair administration of justice stuff or the harmful chilling effect on witnesses, maybe. Then why are you publishing now, Jack? All of it, intentionally. At the hearing related to the protective order gagging Trump, the court acknowledged that the affirmative constitutional duty to minimize the effects of harmful, prejudicial pretrial publicity. They don't want a carnival atmosphere. And then they stopped Trump from distributing these sensitive materials. Trump abided by these restrictions for over a year. Yet now, in advance of predictable national news coverage, Jack's office, illegal, seeks to disseminate protected content of these sensitive materials, including direct quotes and summaries, while the gag order restricts Trump. Trump is still gagged, but they can go out and dump these materials all over the place. Jack's office bears the burden of obtaining authorization to disclose this stuff. His office showing that this issue is unsatisfying at best. They concede that privacy interests at stake are substantial, but they address these issues by saying we'll have some redactions, and they want full redactions of some excerpts. But like Likewise, in contrast to this motion, Jack's office argued in Florida that even summaries, they said, of likely witness testimony constitute paradigmatic Jenks Act materials, which is a release of materials that should remain out of these are like prior witness statements, prior notes, other reports, things like that. They said this should all remain out of the public. And in a separate filing, they said the same thing. Risks, intimidation, harassment, needless, intolerable. Now that public disclosure serves their politically motivated mission, now Jack's office suddenly takes a different view. The office believes that Trump's constitutional right now to impartial jurors in fair proceedings, to say nothing about witness privacy and even safety, all take a backseat to Jack's political goals. Indeed, the office's implicit position is that all of these important considerations must give way to their objective of providing voters across the country immediate access to an unprecedented filing, a monster document with no legal basis, which just so happens to retread all of the false allegations against Trump right as voting starts. How convenient. Contrary to Jack's claim, courts routinely rely on sealed or redacted information to process this stuff. Prosecutors all over this country, including from Jack's office in this very case, regularly seek sealing relief. And there is no legal importance exception cited to justify the protective order. And so for the foregoing reasons, Judge Chutkan should require Jack Smith to make complete, consistent redactions about identity and show cause about why this public disclosure of this massive report is consistent with all of their prior complaints about witness safety, juror taint, and the integrity of the proceedings that they whined about when they were gagging Trump. The defense will promptly meet and confer with Jack's office and discuss further redactions on this court's order. Signed by John Lauro, Gregory Singer, Todd Blanche, Emil Bove, on behalf of President Trump.